Okay.
Okay, here we go, Arthur. So, give a truthful reply when you are asked permission for pertinent information. When it is permissible to ask for information about someone, the person who is asked is obliged to give a truthful answer, even if his reply will contain derogatory facts. This will be discussed in detail over laws of Regel. Okay, even when circumstances permit listening to a derogatory report for a beneficial purpose, it is nonetheless forbidden to accept the information as the absolute truth. The listener should only be suspicious enough to guard himself from possible harm or loss. There's an example here. I just want to see something else here. Okay, so it says so you're not supposed to really believe it. You see, that's let me just read that second paragraph. Even when circumstances permit listening to a derogatory report for a beneficial purpose, it is nonetheless forbidden to accept the information as the absolute truth. Listener should only be suspicious enough to guard himself from possible harm or loss. Okay, the example they give you is Rosie is looking for a good dentist. She is permitted to ask Esther about the merits and the faults of Dr. Kofer. If she clearly states her purpose, Esther is permitted to ask that her experience has shown that Dr. Cohen's work has not been satisfactory. She must be careful to give an accurate answer and not to exaggerate. See, like you said, what you said yesterday, in a way.
Yeah.
So it's a bit weird. This, you see, it's
very similar.
I want to ask you guys something. This is an interesting question. If somebody asks you about Dr. Cohen, the dentist, there's nothing wrong with him. He just happens to be too expensive. Can you say he's too expensive or not?
That's a good question.
Because there's nothing wrong with his work. He's excellent, but he's just too expensive. There's cheaper guys. Are you allowed to say the guy's too expensive?
You're being truthful.
I think what you could probably say is, are you covered by medical aid? And find out if he charges medical aid rates, and find out if there's a surplus and get a quote before you go ahead, because if affordability is an issue, there's two other dentists to also consider, because compared to him, he seems more expensive, although there might be a reason. So that way you're not automatically cancelling him out, but you're making them aware.
Yeah, I think
I told you a good lawyer, Damon.
I went through daf yomi.cia.io. I went through Daf Chaim. I spoke to Rabbi Cohen, and we're having a bit of a contradiction and a problem with different things in this particular thing. But I'm just going to go through it as quickly and simply as possible and see if it's going to help. So, all right, the Gemara states concerning injuries sustained by a person. Okay, right. So we're going to proceed on to a different inquiry, 18A2 at the bottom right. The Gemara proceeds to this new inquiry, and we're going to resolve it on the basis of Rabbi Talfon's view related to our Mishnah. So they inquired, if through an act of Regel, an animal stepped on a child on the premises of the damaged party, in other words, the parents of the child owned a farm, and when the animal, you went into another person's property with your animal, and that animal was walking normally, and it, for example, stepped on a 2-year-old child that was walking on in the grass, killing the child, what is the law regarding whether the owner of the animal pays Kofer? Because this is a case of Regel. Okay, so do we say that the owner of the animal pays Kofer, just as in the case of Keren Muad? So these are the two different sorts of rationale. The first rationale is as follows, is that it is likened to a case of Keren Muad on the following basis. An act of Keren, once the animal does it 2 or 3 times, this is what it says in the Gemara, is the animal's habit, and the owner pays Kofer for it. So what we are saying is as follows. According to Abaya, what makes an animal muad? If after 2 events, it is warned on each separate event, in front of the Beis Din and with all the right procedures. On the third time, it becomes muad, forewarned. And that's according to, that's according to Rava. And according to Abaya, which is the standard rabbinical opinion, 3 times the animal is tame, and then after he's forewarned 3 tame times, on the 4th occurrence, he becomes muad. In other words, the animal is forewarned because that is the habit of the animal now. So do we liken the act of Regel to Keren muad because the animal's natural way of walking or the animal's habit is the same as Keren in that regard, and therefore he pays Kofer for it. Because in Regel, it's also the animal's habit of walking. It's no different to an ox that has now become muad and is in the habit of attacking. So do we say that it works like that? Why? Why would we say it works like that? Because every damager is muad from inception with the exception of Keren. Only Keren we have this concept of half payment damages because the animal is naturally regarded as much more docile. And when it acts 3 aggressive acts on 3 different occasions, on the 4th time, it's known as a habitually damaging animal. It's habit. Whereas man, a pit, fire, Shane or Regel is muad from inception, which means what is the financial implication? It's full payment damages from the first occurrence. Okay, so we're saying is Keren muad likened, where you have to pay Kofer, likened to Regel in the fact that they're both muad. It's the animal's natural habit to walk, and any damage that your animal causes by walking on something at which you have to make full restitution is the same as a Keren muad, that when your ox gores another animal or it injures another animal, in that particular case, you make full financial restitution because the animal's habit is one of aggressiveness. Or do we say that you can't compare this Keren muad because in the case of Keren, the animal has an intention to injure or kill. Mm. One of the unique features, Stephen, with Keren is that it's A, unusual, and B, its intent is to injure or kill. And in the case of Regel, the animal has no such intent. It was just walking normally and has no aggressive intention to kill. But obviously, if a 400-kilogram animal is going to put its foot down on a 2-year-old's neck, it's only going to go one way, and that's it's going to kill the child. And then would we pay Kofer, would we not? So those are the 2 sides of the argument. Okay, the Gemara seeks to resolve this inquiry. Come learn a proof from the following brisa. If one brought his oxen to the yard of the homeowner without permission, and it gored the homeowner who died from these injuries, the ox is put to death by stoning, and its owner, whether the ox was a tam or a muad, pays full kofer. Okay, so now what are we learning as the point of this brisa? This brisa is going through a case of Keren, purely going through a case of Keren. And in that case, it's stating something very, very specific. Whether the animal was tame or forewarned, if it's on the damaged party's premises, according to Rabbi Tarfon, there's full kofer payment. These are the words of Rabbi Tarfon. Okay, so before I go on, can you guys just give me Rabbi Tarfon's view with regards to Keren Tamil Muad, and does he discern between the damaged party's premises or the public domain, from what we learned before?
Damaged parties, sorry.
Yeah, so I wanted to know Rabbi Tarfon's opinion, guys, about Keren Tam. I mean, we all know the case of Keren Muad. We know that whether it's on the damaged party's yard or on the public domain, you would have to pay Kofer if it kills someone, apart from the actual damages. The Kofer is an atonement portion. Stephen, it's an atonement that a person pays because if their ox was continually warned in court proceedings how dangerous it is, and this ox kills somebody, in Shemaim, they hold this person responsible for negligence, that somebody didn't have to lose their life, because this person was very well aware that their animal was dangerous. So apart from paying for that person's death with normal financial compensation, you have to pay a kofer, which is an atonement, because you should actually lose your life and get the death penalty for such negligence. But we don't give death penalties because your property caused the death, not you yourself. But because in Shemayim they know that the person was negligent with a very dangerous animal, and because the animal wasn't tame, it wasn't out the blue. This happened many times, and in that case, he has to make a kofer atonement payment. So, guys, we know that's with regards to a muad. So let's take muad out the way. With regards to tam, what is Rabbi Talfon's opinion, and what is Rabbi Glili's opinion with regards to tam?
I can answer if necessary.
Yeah, I think answer. It takes the heat off the guys.
Okay, I'm a bit dopey. I had a sandwich now, so I'll give it a shot. I'm
Okay.
Dizzy. So Rabbi Tarfon and Rabbi, what's it, Gili?
Yossi Glili.
Okay, I'm not good with names. So both of them basically seem to be of the same opinion, and their opinion is that a kofer payment is no. Rabbi Gili says that you pay half a kofer payment in the public domain for Keren, for a tam animal, for tam Keren, and in the public domain, in the private domain, you pay full kofer payment. Also half.
No. Would you mind if I correct you there? Is that okay with you?
Yeah, just take up. I'm a bit dopey. I know it.
Listen, you took a stab at it. So Rav Yossi Haglili interprets the verse, and the owner of the ox is absolved. Okay? So he basically, this is in Shemot chapter 21, verse 29 and 30. So what does he interpret this view is, it means that the owner of a tam that gores a pregnant woman doesn't pay for the aborted fetus from the damage that goring did to a pregnant woman, because the verse states, and if an ox shall gore a man or a woman, and the person dies, which might refer to a pregnant woman, according to Rav Yosef Haglili's view, there's no verse that explicitly excludes kofer in the case of a tam. So he would rule that just as you pay half damages for tam, so too you pay half kofer for tam in the public domain. Does that make sense? So in other words, let's just examine the public domain. He's interpreting it that the rabbis turn around and say, listen, there is no such thing as a half kofer for a tame animal, because the only reason you have to pay that atonement payment is because your animal was habitually dangerous. You've been warned in the court, and therefore you were negligent in causing that death. If your animal is tame, Gavin quite rightly said yesterday morning that it could be that the animal still was a bit aggressive, because it could be your third time to come to court, where the animal is still technically tame, but then you would know that this animal is dangerous. So Gavin is completely correct there. But at least the logic follows that for a muad, you should definitely know better. So according to the rabbis, there is an exclusion of tam, whereas Rav Yossi Haglili is basically saying, it says that if you ox shall gore a man or a woman, and it's not an exclusionary term for tam, but just for the woman's fetus, if it gets damaged in the act of goring, from the kofer payment, not from actual damages to her or the infant, but for the responsibility point of view of atonement. So he's saying that for tam, just like you would pay for tam half payment damages in the public domain, and for muad food damages in the public domain, and the same occurs in the private domain, so too you'd pay half kofer damages for tam in the public domain. Now, whether one pays half or full kofer in the private domain would depend on whether Rav Yossi Haglili follows Rabbi Tarfon or whether he follows the sages, because the sages say that the law is not divergent. what it's saying is that in terms of the biblical passage, Scripture doesn't denote a particular location where care and damage takes place. And therefore, it is the same in a public domain or private domain. That's according to the sages. So if Rav Yossi Haglili, who's a third generation Tana, goes according to the sages, he would say that you have to pay half kofer for tam, both in the public or private domain. But if Rav Yossi Haglili is going according to Rabbi Talfon's opinion, he would say half payment damages for kofer tam in the public domain, and in the private domain, full payment damages for kofer tam.
Damon, sorry, not to be rude. Sorry, I was basically saying that. I just think I.
No, you didn't say that, because what you, Gav, I want you to listen to the recording again. You didn't say that. You didn't say that.
Well, that's what I meant to say. I thought I said.
No, I believe you, but you didn't. What you actually said was you were talking about Rav Yossi Haglili, that in the private domain, that he asserts that for Keren Tam, the kofer part, you pay full damages. And
No, I meant that for not for Tam, for Moad.
Okay, but I'm saying I can only work on your words.
Yeah, no, sorry. I said I'm a bit dopey. All right, carry on.
Okay, so I know you know it. I know it's like sometimes the words don't come out right. So,
didn't come out at all. All right, carry on.
Okay, so this is one of the issues Gavin and I had last night, is that who came first, Rav Yossi Haglili or Rabbi Talfon? Because this is the problem, is that Rabbi Talfon is a second generation Tana. So he technically came first.
Okay.
And in this case, it makes sense where it says Rav Yossi Haglili, if he's holding according to Rabbi Talfon, he'd pay full kofer as well as full damages on the damaged party's premises for Keren Tam. But the problem is later on in the Gemara, it says Rabbi Talfon, if he's following Rav Yossi Haglili, in that particular case, what's happening is maybe that's where he derives his law. So what's the problem there? The problem there is as follows, is that who's following who? It's more likely that Rabbi Glili is following Rabbi Talfon because he's a third generation Tana. And here it's saying which we'll read in the Gemara now, it seems that like Rabbi Talfon is following Rav Yossi Haglili, which is possible because there was a certain period of time where they overlapped. I think 20 or 30 years in terms of their lifespan.
Okay.
But I don't know if they were both. I don't know if Rav Yossi Haglili was too young and Rabbi Talfon was too old, or they managed to learn together. But the Sephora uses better wording. What wording does it use? It uses the word, he agrees with the same line of thinking as Rav Yossi Haglili, Rabbi Talfon. So if you're saying, I agree with your thought process, it means the way that we learn together is of the same sort of methodology. It doesn't mean I learn from you or you learn from me. It could just mean that we're sharing methodologies together. Does that make sense? Okay. In other words, how we learn a tradition of learning, we're interpreting it in the same way. So I think if we learn it that way, we're pretty safe, and then you're not going to have a contradiction.
Okay.
Gab, that was very useful what we did last night.
No, 100%.
James, can I just...
And well communicated now. Well, thank you.
Sure.
I just want to see how I got it clearly. Okay, so Rabbi Gili is almost using the same thing from the public domain, in the same theory for the Kofer. I mean, if you get killed, right? I'm talking about from damaging. If you got killed, he uses the same thing. If it's in a public domain, it's half. No. So what did I misunderstand?
This is what Gavin initially said, but I know he got it right. That's how he initially said it. So they've got two different mindsets here. Okay. So how the mindset comes as follows, and it's a great question. Now I know that you're with it, John. You're absolutely with it. Is that if we have a look, again, Shmot, Exodus chapter 21, verse 29 to 30. That's where we actually get the exposition. And also by Midbar, Numbers chapter 35, verse 31 to 32. That's where we get our context. So how's it coming about as follows? is Rav Yossi Aglili is saying, listen, the rabbis, firstly, let's see what all the general opinion is. The sages say that Kofer is only for a muad animal, and it excludes, it uses the term I love. It's got an exclusion. It's because of this. It's because of this. This is what I love means. So it's got an exclusionary term, which means the rabbis interpret it as anything to do with a tame or chilled animal. You're not responsible for the atonement. When we say tame, Gavin's right. It's not like it hasn't done it before, but it's not like it got the status in Shemayim by the Beis Din and Sanhedrin that this is an animal that is officially a habitual injurer or killer. It's different to have that status in Shemayim, even if it had a behavior track record. It's like somebody being branded a convicted killer versus having a lot of charges for assault and battery. Are you with me, Gavin? The minute the Sanhedrin does something or the Beis Din does something on earth, it has an effect in Shemayim. And when on earth they give it a status of muad, all of a sudden in heaven, you've got no excuse. It is a full responsibility to not have that animal. That animal should have been put to death at that point when it became a muad. Before it attacked again, you should have got benefit from the animal, sold it a steak, and cut your losses. Does that make sense?
Why didn't they just do that? Just 1 second, Dave. Why didn't they just make that into a practical solution? As soon as the animal does it gores 3 times, if you're following the second approach, then automatically put the animal to death. That's what they should have done.
It might have been that, Gavin, you're right. It might have been in later generations they forced the people to do it.
Yeah, it makes so much sense. I know this is a lot of it is theory, so they might have changed it. It was practical at the beginning, but they might have switched it later.
Yes,
it does make sense.
Correct. People lost certain free choices. In the old days, you could marry a lot of women. Today, men look haggard marrying one person. They made it one wife. People change, laws change. So the thing of it is they might have turned around and said, this thing's becoming boerewors and steak, and you've got no choice here. So Rav Yossi Aglili's opinion is nothing to do with private or public domain at all. His only opinion is the exclusionary term isn't a tame animal. He said, I see nothing like this in the source. The only thing I see is it says, and if your animal will gore a man or a woman. So what does it exclude? A non-born baby that is still in the fetus because it's not born as a man or a woman, or a boy or a girl. So in that case, if it happens to gore the mother and kill the fetus, you pay the damage to the mother and for the fetus value, but you don't pay the atonement aspect.
Yeah, I know.
For that. So that's his shtick. Now we say, well, what is his shtick with regards to a public or private domain? We say, listen, it depends. If he agrees with the sages generally, then it's not going to make a difference with Keren Tam if it's in the private or public domain, because just like the damages of Keren Tam or the public or private domain, you'd pay half payment. The law is not divergent. It's the same because there's no specific scriptural source for location. Then it would make no difference. You still pay half payment damages for time, no matter where it occurs. If he agrees with Rav Tarfon's methodology, which he could do because he came later, then there would be a difference, is that he would then hold full payment of Kofer for a time if it occurred in the damaged party's premises compared to the public domain. It's not clear in terms of where he holds on that issue. Okay.
Yeah.
So we're not now. What we're going to discuss is how Rabbi Kofer ends up getting the same sort of methodology from Rav Yossi Aglili, and the only way he could get the same methodology is in their lifetime, if they crossed for like 10 years or maybe a year, maybe they only had to cross for a year and discuss it in a yeshiva, and get together, or he might have learned from him in terms of the same methodology. Because if Rabbi Tarfon came earlier, it would have been difficult, unless the two paths crossed, or the methodology was the same. So let me go on. By the way, does that answer your question?
Yeah, I'm getting it. It's this is a very complicated one. I spent hours going through this, but it's getting clearer.
Okay. So all right. So John, please, you've got a point of clarity. It's like the eye before the storm. So
I appreciate it.
All right. So what we're saying here is as follows. The Gemara develops its proof. Now, where would Rabbi Tarfon derive full Kofer in the case of a tam? Is it not because he holds the view of Rav Yossi Haglili, okay, who says that the owner of the tam pays half Kofer in the public domain, and Rabbi Tarfon derives full Kofer on the premises of the damaged party through a fortiori argument, a Kal V'chomer from Regel. So what is that case? We learned that originally, that there is Kofer, thus we see there is Kofer paid in the case of the Regel. Now, do you remember what that Kal V'chomer argument was, or do we need to go through it? A second. All right, I'll read the Mishnah.
I know it. I'm just blank. Just go ahead.
Is it okay, Gav, if I go ahead? Because I don't know.
Please. It'll be quicker as well. Yeah.
All right. So this was a Mishnah on page 24b3. It was actually a Mishnah first repeated in 15b and with more detail here. What is the case of a bull that damages on the premises of a damaged party? If it gored, pushed, bit, squatted, or kicked, and thereby damaged something, if it did so in the public domain, the owner pays half damages. If it did so on the premises of the damaged party, Rabbi Tarfon says he pays full damages, but the sages say he pays half the damage. Now, Rabbi Tarfon said to the sages, I derive my ruling from the following Kal V'chomer. If in a case where the Torah was lenient regarding Shein and Regel in the public domain, in that the bull's owner is not liable to pay at all, we find the Torah was stringent regarding them on the premises of the damaged party by obligating the owner to pay full damages. Okay. Then in a case where the Torah was stringent regarding caring, where the owner had to actually pay half payment damages, is it not logically compelling that we must be stringent regarding it on the premises of the damaged party and obligate him to pay full damages? Okay. So the sages say, now just remember there that if we applied a dayu, it is sufficient, we wouldn't have learned anything because the sages say the law isn't divergent. So Rabbi Tarfon just incidentally does apply a restraint, and he say that you pay the full damages from the gufa of the damaging animal, not from choice property. So he still has a dayu, some way to nullify the Kal V'chomer. Does that make sense?
Yeah.
Instead of from choice property. The sages are saying nothing doing. The sages say to Rabbi Tarfon, it's sufficient for the derived law, which is keren on the premises of the damaged party, to be the same as the source law, keren in the public domain. Just as in the public domain, the bull's owner only pays half damage for keren, so too in the premises of the damaged party, it pays only half the damage. Now, Rabbi Tarfon has got an argument for them. Now, it's not that Rabbi Tarfon changes his mind and feels that the first Kal V'chomer is weak. Now he agrees with the first Kal V'chomer. He's now just going to say it in a different way for them. And it's actually the same sort of Kal V'chomer. Rabbi Tarfon says to them, I too will not derive the law of keren on the premises of the damaged party from the law of keren in the public domain. Rather, I would derive the law of keren on the premises of the damaged party from the law of Regel on those premises as follows. If in a case where the Torah was lenient regarding Shein and Regel in the public domain, and it was stringent regarding keren, then in a case where it was stringent regarding Shein and Regel on the premises of the damaged party, where it obligates the bull's owner to pay full damages, isn't it logically compelling that we must be stringent regarding keren and obligate the bull's owner to pay full damages? So even regarding this derivation, however, the sages say to Rabbi Tarfon, it's sufficient from the derived law to be the same as the source law. Just as in the public domain, the bull's owner only pays half the damage for keren, so too in the premises of the damaged party only pays half the damage. Okay.
Yeah, thank you.
So Gav, it was worthwhile going through because now they see where the laws are based.
Yeah.
So now we're saying, okay, firstly, Rabbi Tarfon holds of the same mindset of Rav Yossi Haglili, that interprets that in fact there's no exemption for tam regarding Kofer, it's just like you pay half tam for damages, you pay half kofer for tam from Keren. And now he says he's going to apply that same Bava Kamma with regards to Regel, that it's full damages for Keren tam, or in this case of Regel, there's full damages for Regel because it's on the premises of the damaged party. Does that make sense?
Yeah.
And what we asked in the beginning of this year is, does it resemble Keren in that Keren is generally muad, and it's the fact that Regel is always muad? Is it that part they have in common? Or is it dissimilar in the fact that Regel has no intent to damage, whereas Keren does? That's what we're trying to establish. And you can see from Rabbi Talmud's response that he says that, listen, the laws are similar in the sense that at this point, we base it on Rav Yossi Haglili that says that there is half payment for half payment for Keren for the Kofer for Keren tam, because there's no exclusionary clause for tam. It's just half, because you still are obligated for an atonement payment. But the Bava Kamma is that you should definitely pay full Kofer for Keren tam and Regel on the damaged party's premises. So there is a bit of an issue here. One of the issues that I can see is that how do you equate the two? Because in the beginning, if you want to say, listen, it's similar to, Regel is similar to Keren in that they're both muad, does Rabbi Talmud think doesn't clear it up? Because in this case, they're not similar. You're talking about Keren, which has a tam status. Does that make sense?
Yeah.
And if you want to say it's dissimilar, because Regel is just, it's not habitual, but it's chilled, and Keren is the intent to injure or kill. It still has nothing to do then with Regel. Keren and Regel then have nothing to do with each other. So Rav Yossi Haglili is clear. He's saying, listen, I get mine from a scriptural verse. There's no exclusionary term for tam. So he's just not even going down the Regel route at all. All Rav Yossi Haglili is doing is going down the Keren route. And he's saying, listen, for Keren, for actual damages, if it's half payment, if it's muad full. The same for Kofer, there's no exclusionary term for tam. It's only for an aborted fetus. So for the tam aspect, it's half Kofer for half atonement. And for if your animal is full warned, believe me, it's full Kofer, because you should have known better, because it's got an official statement as being forewarned as destructive. And in that case, it's still only half payment for Keren tam. It doesn't matter if it's in the damaged party's yard or in the public domain, if he's going according to the view of the sages. Obviously, according to the review of Rabbi Talmud, it would have more stringency in the damaged party's yard. But if you want to learn Rav Yossi Haglili according to the sages, it's pretty clear. It's not obscure. There's nothing obscure about it. Again, he's not dragging Regel into it. He's not adding Bava Kamma. He's the only thing he's doing is interpreting the scriptural verse differently. He's not confusing. Am I wrong, Gav?
No, I agree. So we have to wait for Eliyahu and Avi to tell us what's right.
We've got a few minutes left. We're going to then tackle this issue tomorrow. So all you've got to know, Rabbi Talmud bases his view on the same way of learning as Rav Yossi Haglili, who said that the owner of a tam pays half Kofer in the public domain, and Rabbi Talmud derives the full Kofer for tam on the premises of the damaged party through the Bava Kamma from Regel, with that stringency we just learned in the Mishnah. Thus we see there is Kofer paid in the case of Regel according to Rabbi Talmud. That's it.
Okay.
In terms of why and how we'll break up tomorrow. I hope this helped, Gav, as a start.
Yeah, no, it did. Sorry.